The Advocate General, Europe's most senior legal advisor, has recently issued an opinion on the subject of whether obesity qualifies as a disability in the workplace. The impact of this decision is that if obesity is classed as a disability, it will be unlawful to discriminate against a member of staff in the workplace on the basis that that person is obese. Discrimination is unlawful in the workplace when it is on the basis of one of 9 protected characteristics. These include age, race, sex, sexual orientation, religion or belief, and disability. In accordance with the Equality Act, a person will be classed as disabled for the purposes of employment law if that individual has a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Employees who are classed as disabled have a right not to be treated less favourably than other members of staff as a consequence of their disability, and further, there will be an obligation on employers to make reasonable adjustments for these employees to ensure they are not disadvantaged by their condition. Previously, obesity was not capable of constituting a disability in its own right. Obese employees would only be covered by the discrimination legislation if their obesity gave rise to another condition capable of constituting a disability, for example, diabetes or arthritis. In these cases, the employee would be protected from discrimination on the basis of the condition arising from their obesity, rather than their obesity in itself. In a recent case, a childminder in Denmark claimed that the reason he was dismissed by the local authority that employed him was due to the fact he was overweight, and that this constituted unlawful discrimination. The Danish national courts referred the question of whether or not the obesity alone can constitute a disability to the Attorney General for his opinion. In the first part of the opinion, the Attorney General confirmed that obesity was not a protected characteristic in itself under the Equal Treatment Framework Directive. This principle is already well established, and therefore this decision is unsurprising. The second and more interesting aspect of the opinion concerned whether or not obesity fell within the definition of a disability. The Advocate General noted that the EU definition of a disability covers the situation when a physical or mental condition makes the carrying out of that job or participation in professional life objectively more difficult and demanding. Typical examples of these are handicaps severely affecting mobility or significantly impairing the senses such as eyesight or hearing. He went on to say that in cases where obesity had reached such a degree that it hinders full participation in professional life compared to other employees due to physical or psychological limitations, then it can be considered a disability. The emphasis is on can rather than must, which means that obesity will not qualify as a disability in every case. In the Advocate General's view, only extreme, severe or morbid obesity would create such problems with mobility, endurance and mood to fall into the category of a disability. To fall into this category, an employee will usually have a body mass index of 40 or more. This does not mean that every person with a BMI of over 40 will suddenly find themselves being classed disabled for the purposes of employment law. Instead, the position is that if an individual has a BMI of 40 or more, they might be disabled if the obesity has a real impact on their ability to participate in work. If the obesity does not have this impact, they will not be classed as disabled. The Court of Justice of the EU will need to make a final decision in relation to this issue, and the British courts will be bound by the decision that the court makes. The court normally, but not always, follows the opinion of the Advocate General, and a judgment is expected within 4 to 6 months. If the judgment of the Court of Justice and the EU does confirm that obesity can be classed as a disability in its own right, British employers will have a duty to ensure that overweight workers are not placed at a disadvantage by reason of their weight. This could involve employers having to make costly adjustments for obese employees, such as providing larger chairs and desk equipment, altering any facilities employees may use, providing parking spaces nearer to the building, and altering an employee's duties so they require less mobility. Clearly, this decision could have significant implications for employers in England, and we therefore await the EU's decision with interest. For more information or guidance, please contact us.